testify with regard to the situation. So thank you.
And I'm sure you're going to provide a copy of that article to the clerk for distribution.
I will provide Tricia at the State House. I will provide you a copy of this document inscribed for Tricia at the State House. This document will be in perpetuity, Senator Gray. In perpetuity. That's how valuable this document
I mean,
will
we
be.
just built Archives, a new building, right? So
Right.
there's plenty of
room. Plenty of room. So thank you.
questions from committee members. I have some.
Yes.
Currently on a vehicle, when you register it and fill out the paperwork, you can put the proper identification on there, I believe, to transfer it on death to the other owner. Is that right? Someone else may know.
Someone else may know, but having seen a couple of vehicles smashed up in the last couple of months, I can tell you the transfer of the vehicles to somebody is part and parcel of the deal. But I'm not specific with regard to your question. Someone else will have to address that.
Is this compliant with all of the estate laws that we have out there when someone creates a trust? Is this all compliant with all of that?
As far as I know, yes. The caveat being we're creating a new section of law here. We're creating the transfer on death deed. So it's a new section, and I'm assuming it's in compliance.
Just for administrative purposes, someone didn't turn their mic on. Mea culpa, mea culpa. So I need to repeat the bill number, Senate Bill 243. My problem with this bill is that when we get into assets and probate and other issues of that, that if there is a creditor out there and the home may be the only real asset that the couple has, that the creditor may not be able to access any of that if this is transferred. How is that covered in this bill?
I really don't have an answer to that. I don't know. I don't know. The only thing I can say is this is a methodology that's been accepted in many states around the country. And as a result of that, we took something that was in place someplace and brought it to New Hampshire. So it created a new body of legislation. But I don't know. I don't know.
All right. Any other questions from committee members? Thank you, Senator.
Thank you very much, Senator. Appreciate that.
There are two other people who have signed up. Barbara.
Thank you, Will.
Go ahead.
I'm good. I hope you can hear me clearly through this mask.
Sit close to the mic, and that helps.
Okay. So I have something to say, and I also sent written testimony. My name is Barbara Schultz. I'm from Goffstown, New Hampshire. But I am not a lawyer, but I can address the question that you asked about the creditors. It does, in fact, leave this open. It's not going to have a creditor not be able to get to the asset. And in fact, in talking to estate planning people about this, they have indicated to me that it is a potential drawback for someone, that yes, it leaves it vulnerable to a creditor, okay? However, and getting to my testimony, there are many, 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 many people out here where I call them regular Joes like myself. Our house is the only asset that we have. And in planning for estate planning, I don't need to create an estate. I don't need to set up revocable trust or living trust or anything. I don't need all that complexity, and I certainly don't need all that expense. And so this is something that I first read about in the Union Leader in 2020. And I got very excited about it as this is perfect for me, a single person. This is what I need to transfer my house, and I'm pretty much all set, only to find out that it was not available in New Hampshire. So I'm not sure why the Union Leader ran it, but I submitted written testimony in support of this bill to all of you, but I wanted to be here to let you know that it matters to me, and it will make a difference, and I think it will make a difference for a lot of New Hampshire citizens. The transfer on death deed is a useful and important tool to provide easy and inexpensive transfer of property, and it should be available as a tool. It may not be recommended. It may be, hey, you don't want to do this because creditors could access it, but it should be in the toolbox for citizens to make use of if it fits their situation. You know, I will repeat all the reasons and benefits that I mentioned in my written testimony, trusting that you have either read it or will in fact read it. But you know, one of the things is it could actually free up the probate courts, because if your house is the only major asset that you have that forces it to go into probate, you know, it's possible that it could free up some space there in the probate courts, and the probate courts might even appreciate that. So it's a very simple thing. To me, the easiest way I explain it to people is when you have joint right of survivorship in a house, when you have, say, a married couple together on a house, someone passes away, it just, boom, goes right to that other person. This is, in my mind, the same thing, quote unquote, the same thing for a single person who doesn't have that person to put on joint and right of survivorship. And the other thing, too, if you do that during your lifetime, for example, if I added a relative as a joint person, that in fact can implement some gift tax problems, because you're actually sort of gifting the house. So, and I don't want to do that. Transfer on death is simple and clean, and it also leaves me with freedom to change while I'm owning the house. I can make lots of changes inexpensively. If I want to change the beneficiary, I can do that inexpensively. If I have a trust document, it's much more complicated, much more complex. So I ask you to definitely support this bill, and I thank you for that support. It's something that regular people with simple estates and simple assets would really make use of.
Thank you. Question, Senator?
Yeah, thank you. And I don't know if this question is properly directed to you or if anyone else is going to speak, but what's the difference between this and just transferring your property today and giving yourself a life estate? I mean, is there a legal difference between those two things?
The difference, I don't know too much about a life estate. The difference is that, say for the little bit that I do know, and again, I'm not a lawyer, so don't hold me to this, but say you set up a life estate and I want to maybe take out a second mortgage, or I want to make some other change, you have to get those other people to sign off on that before you do it. Transfer on death deed, you do not have to do that.
Sure.
I maintain total control.
Sure. And follow up?
Yes, ma'am.
I know you mentioned other states have this, or maybe the senator did. Do you know how many other states have adopted this?
I actually had a list, I didn't bring it with me, but it is a majority of the US states. It is more than half, for sure.
Thank you.
So there's one state, and I'm throwing this out there, probably Texas, they have a transfer on death deed that they refer to as a ladybird deed, and I don't know, but it's the same thing with a different name.
Okay. Thank you.
Additional questions? Okay,
Thank you much.
Next on the list is Susan Kerrigan? Cragen. Sorry, I never did well in that.
Thank you for allowing me to speak, Chairman and members of the committee. I was going to say you may have recognized me from prior testimony, but it appears that you don't. I'm the Merrimack County Register of Deeds, and that's why I was given this bill to take a look at. I took a look at it, and I'm not testifying in support or opposition, and I'm not testifying on behalf of the Registry of Deeds. I'm testifying to point out something that I think is a little odd about this bill and needs a little bit more consideration. And I have a personal story to go with it. So we've heard from people who want to deed property. I represent the beneficiary point of view. And I am testifying about Section 563-D:10, Notice Delivery Acceptance Consideration Not Required. My husband was recently bequeathed by will 1/4 of a house when his mother died, and he immediately disclaimed the gift. Why? He didn't want the property, and there were 5 good reasons why he didn't. There were environmental hazards that my husband had notice of. The water wasn't potable. There was black mold in the basement. Decades-old fir trees grew within a couple of feet of the house, one of which could crush the tiny house in the right wind. The woodpile had been kept too close to the house. There were obligations that ran with the land that he didn't want to take on, including partial responsibility for keeping a watercourse clear. He thought a creditor lien might exceed the real value of the property. He had cash that the bank could go after if it filed a deficiency action. 4, ownership would be partial among 4 siblings, 3 of whom wanted to keep the house for sentimental reasons. One of those 3 we suspected was insolvent and knew was irresponsible with money. And a second mentioned using it as a weekend retreat for a religious group we disliked. And those were the 2 siblings my husband got along with. If my husband had not disclaimed under the will, he would have had to take time to go to New York State and get a lawyer to arrange the transfer with resultant expenses and headache. My husband had asked his mother to keep him out of the will, but she was unwilling to treat him differently than his siblings. That's a common feeling. The American Association of Retired People put out an article on 6 good reasons to decline a request of real property. And I will send you the link to the website, and I'll just read them off quickly. It's a good tax move if the property will then go to someone who has a lower tax consequence. It's a dog of a property. It will trigger a government aid eligibility review. So for instance, if it's being given to someone who's in a nursing home or who receives other government assistance, it will trigger a family drama. Or it will go directly to your creditors. For instance, are you on the brink of bankruptcy? And number 6, it's the right thing to do. If people are getting real property, they need to have the opportunity to turn it down before it becomes a law, before it becomes theirs. And this provision doesn't work. And I'd like to also point out that a lot of what makes this law seemingly a good idea is that it is one of the uniform laws put out by the Uniform Law Commission. And supposedly everyone's gotten together and decided that this is the best way to do the law, this is the right way, this is the way all the states should do that. Well, they did the same thing with the remote online notarization law. And then this year, they passed another one, and they told everybody who'd passed it, including New Hampshire, that you better turn right around and repeal it and put the new one up. So the Uniform Law Commissions, the laws that they put together are not always perfect. They're not always well considered. And I think that this, which is all just boilerplate, needs to be gone over carefully by this committee. Any questions?
Questions from committee members?
All right.
Are you familiar with the statutes in New Hampshire that talk about states that are small and the different requirements that are required, or the less stringent requirements that are required for them?
No.
Okay, thank you.
Yep.
Are there any other questions? Anyone else in the audience that would like to speak? With that, we'll close the public hearing. And the clock says that I'm ready for Senate Bill 244 relative to the non-conforming structures and variances, and introduce the prime sponsor, Senator.
Thank you, Chairman Gray and members of the committee. My name is Kevin Kavanaugh. I'm Senator from District 16, representing the town of Bow, Candia, Dunbarton, and Manchester wards, Hooksett and Manchester wards 1, 2, and 12. I put this bill in at the request of a constituent, Attorney John Cronin. Let me just grab this. The bill makes allowances for certain non-conforming structures and make changes to the definition of subdivision. I did speak with the Department of Environmental Services last week and did offer an amendment to the first section, Amendment 0220S. And I did show that to Attorney Cronin as well. There is a lot of complex parts to this bill, and Attorney Cronin has 35 years of experience in this field. And I just wanted to present this, and I know the department had some questions, and I'm willing to get together with the department and Attorney Cronin to make any changes to the second two parts of the bill, just to help the bill go forward, but also help both sides to be being in favor of this bill. So with that, I'd try to take any questions that I can answer, but I can tell you one thing, Mr. Attorney Cronin is going to have a lot more experience in this than I do. Thank you.
Okay, thank you very much. Trish, did you give me the new sign-in sheet? Any questions? Senator Perkins-Coie.
Yes, and I will save my more detailed questions for Attorney Cronheim, but just as an overview, what is the problem we're trying to solve with this?
Well, with the amendment, what this does with the department, if there was a primary structure
Yep.
and you had another building closer to the shorefront, the
Yep.
waterfront,
Yep.
it would protect the shoreline, that you couldn't have another ADU be closer to the primary building.
Got it. Okay, thank you.
There you go.
Additional questions from the committee? Thank you, Senator.
Thank you.
And you're suggesting that I call John? Come on up.
Mr. Chairman, distinguished members of the committee, my name is John Cronin. As Senator Kavanaugh said, I'm an attorney with a practice based in Manchester, Cronin, Bisson, and Zielinski. And as they say, old age has its privileges. I've been privileged to work in the land use arena for those 35 years, handling probably between, trying to figure it out today, at least 500 and maybe more than 1,000 cases at local planning boards, ZBAs, and the DES, and a lot of other administrative agencies. In addition to my work as a lawyer, I've also served as a former member of the New Hampshire Real Estate Commission, served on the board of CYBOR, the Commercial Industrial Board of Realtors. and the past president of the New Hampshire Apartment Association. In that capacity, I served on the Governor's Lead Paint Commission. Currently, I'm the chair of Catholic Medical Center's Board of Directors and also chair of the Manchester Police Commission. So have some background in these particular areas. This bill before you today, I know your procedural pieces say that it's partisan, but I'm happy to report Representative Varney, who hoped to support this but had commitments in his fire chief duty at the time it was submitted, has sent along his support for it, and he's worked closely with us on a specific project I'll get to later in Wyndham. And we know people come in all sizes and shapes and political persuasions, and I think people of every type and kind own older properties that suffer the same consequences as the one I'll discuss with you today, in which this bill is aimed to correct. With respect to the bill, there's three parts to it, and they're independent. Neither one of them is reliant on the other, and I would suggest that the first two pieces, which adds the new section regarding ADUs, is one which there's probably not too much controversy about. Compliments to the legislature in adopting the ADU bill. I think it's been a tremendous success. In my practice, I've come across things where people have, say, an existing outbuilding that was built long ago would be appropriate for an ADU, but it may not meet a current setback. And I'll give you an example. Current zoning may have changed to say the setback is now 20 feet from the side yard line, where this building is at 15 feet. It's been there for a long time. It's going to stay there for a long time. And some communities say we can't consider an ADU because it's not compliant with existing zoning. It's a shame, really, because, as I say, the success of the program and the building's not going to go away. I did get a copy of the proposed amendment. The specific language of it I have some concerns with because I think it guts what we're trying to accomplish. But the goal of the amendment I totally agree with. I believe DES says they don't mind about some of these remote side setbacks away from the water, which the great majority of these ADUs are. But they don't want someone that has an accessory building now, say 25 feet from the shorefront, that can only be used in an accessory building to be converted to living space. And we have no issue with that and believe that we could accommodate the DES's request and get a win-win situation. The second piece, which is at subsection 2, that relates to the special conditions category and unnecessary hardship. And I know many of you have been around for a long time, and variance law has gone through a lot of different iterations through Simplex and Boccia and others. And we've changed from having both use and area variances to now one consolidated test for variances. And this specific conditions language and specific conditions or special conditions, it hangs up a lot of the Superior Court judges. It seems that the local communities understand it and can manage it. But in fairness to the courts, when they look at these statutes, they look at them literally. And the variance test has 5 prongs. Someone seeking a variance has to show that if it's granted, it will be in the public interest, the spirit of the ordinance, will grant substantial justice, will not diminish the value of surrounding properties, and that there's an unnecessary hardship. We're not seeking to remove any of those, but special conditions is such a vague and subjective standard. It's very difficult to get your arms around, and it does nothing to the 5 criteria. When you look at it, all we're looking is to strike that. We're not looking to take away any power from the municipalities. Those 5 conditions will still exist. And that special condition situation is most problematic in fully developed communities. If you're in a remote community with virgin land seeking to be developed, it would not be as much of an issue. But in communities where I live, like Manchester, Nashua, Concord, and Portsmouth, where if you looked at a lot of the majority of existing improvements, most of them won't comply with the ordinances that were adopted today. So you could have one building, if you're proposing a new development, they're saying you have to comply because of special conditions with existing zoning where everyone around you does not. And I think that's led to some unfair results. I see that this is a housekeeping effort more than anything else, and I don't think it's tied to the ADU or the next topic on which I'm about to talk to you about. And I think the subsection 13 relating to subdivision is probably the most substantive and the one that will have the most impact to property owners and people in New Hampshire. This particular bill being proposed came about by a specific property, but it's not a property-specific legislation because we've dealt with similar type properties throughout the state. Newfound Lake over in Rye, Squam Lake. There's a number of old cabin communities, so to speak, that were developed, say, prior to the 1960s that have been used for a long time. There's an Ouellette family. Many of them are with us today. They're the third generation of operators of a property called Sandy Point. Yeah, it's up in Alton, right on Route 11. It's 4.4 acres, and it's intensely developed. I think development there started in the late 20s and continued until it was stabilized. They had a restaurant that was operational there, and there's a lot of different improvements. I think I'm just going to walk you through the binder here because it may give you some reference as I talk about this quickly. I've provided binders. I hope each one of you got one. Just at the cover is the text of the legislation. At tab 1 is the support from Representative Varney. Tab 2, we have a number of signatures, and keep in mind that this effort started on January 19th, and I think there's well over 100 signatures there. I'll speed it up. At tab 3, there's some legal pieces, the Condominium Act, which allows conversion of existing improvements, and also at tab 4 is the tax information. So what happened is the Ouellettes were approached by a New Hampshire developer who was interested in acquiring their property. They had successfully redeveloped some cabin communities on Winnipesaukee, one in Center Harbor and one in Laconia. Both of those were on sewer. They approached the family and came to an understanding. Price range from a number of different suitors is around $12.5 million. Current assessment is 2.6, generates about $29,000 in tax revenue per year. If these buildings were allowed to be converted to condominiums, there'd be additional capital improvement to renovate the existing buildings, remove the restaurant, add green space, and build a brand-new septic system. When you look at a septic system, because of the nature of the size of the property, which is 4.4 acres, you can't make it 100% compliant with existing regulations. So, for example, if you took the existing system, which works fine and will remain if this bill isn't passed, and those structures will remain as they are without improvement, you say you're at 25% on a 100% scale. If this is redeveloped, you'd probably go to 75 to 80% compliant on a 100% scale. We went to the DES, had a meeting with them. Representative Varney attended. Town of Alton has generally looked favorably on this development and a transformation to condominiums, but no specific vote is taken. The DES entertained, and I've worked with them often, they've been very helpful in a lot of cases, and they said, look, we can't provide a waiver with this because it relates to the definition of subdivision. And I think this cries out for a waiver because there's no effort here to diminish water quality, hurt the impact, it would improve it by any measure. They said they couldn't do it, so we talked with Representative Varney and others and said maybe the right idea is to seek to amend the definition of subdivision. And all we're asking in this particular bill is the definition of subdivision do not apply to the conversion of condominium of an existing structure, one that already remains and wasn't going away, to condominium form of ownership, provided that the footprints, the building footprints aren't going to be increased and the number of bedrooms which drive the flow of septic usage are not increased. We believe that this bill will have tremendous impact on tax revenue, not only on this property, going from roughly $30,000 to $300,000 a year is a significant impact without any diminished impact on fiscal services such as fire and schools. But you will get buildings that are more compliant with building code and more compliant with life safety code. Again, we look forward to working with Senator Kavanaugh and the DES on this. I think we can get to a point where there's a win-win and there's no intent to harm the water. And I think when you look at the supporters, most of them are Lakes Region residents who have a vested interest in the quality of the water in Lake Winnipesaukee. Thank you.
Thank you. Questions from committee members? Senator Perkins Polka.
Thank you, Chair. Thank you for being with us today. I have a few questions. Okay, so thanks for walking us through the bill, and it's helpful to know that these are three sort of isolated requests. You mentioned with section 1 that you had some concerns about the amendment brought before us today because you thought it could undermine it. Can you elaborate on that a little bit?
Yes, I looked at the amendment, and it seems to talk about the wetland piece of it. It makes reference to another statute, and I have no objection to that. But it takes out that language that we propose to allow existing non-conforming structures to be converted to accessory dwelling units. And my thought was if we added language provided there beyond the reference line, which is 50 foot from the waterfront, that may satisfy DES's concern. When I was looking with this originally, I wasn't thinking of their issue of, okay, someone might have a gazebo that's 25 feet off the water, and if this passed as written, someone could, put some windows in it and put some insulation and move into it. That's a fair concern of theirs, and that's not what we're looking to accomplish. And I know Senator Susi knows Manchester better than I do, but we've both been around for a while. If you took something, say, over on Candia Road, no impact to the water, miles away, if they're within a few feet encroaching on a setback that's new, and the building's going to stay there anyway, what harm is it to anyone to create an ADU? Going to increase property value, going to get a building that's newer, more compliant, renovated, better curb appeal.
Okay, thanks. And then follow up, if I may, Chair.
Yes, ma'am.
Thank you. When in section 1, the policy intent here is clear, and I think that's fine. When you talk about existing nonconformities are not increased, are you talking about nonconformities of the structure or the lot or both?
When I use non-conforming to municipal ordinances, so when I talk about that, I mean most zoning ordinance will have, let's use a side setback, for instance, and say you have to have a 20-foot side setback from your neighbor's property line. If a building already exists and say it's been there since the 60s, back then it might have only been a 10-foot setback. So technically you're violating today's ordinance, but the building is already there, been there for a long time, and not doing any harm.
Yeah, no, I know what a nonconformity is. My question was, when you drafted this, are you intending for it to be the nonconformities of the structure or the lot or both? Are they supposed to be cumulative? Okay, we may just want to clarify that. Follow up, if I may, Chair.
Yes, ma'am.
On section 2, I guess I view this as a pretty big change. I mean, you're essentially taking away some ability of the zoning board and its adjudicatory function to determine, whether under the strict criteria they can grant a variance. There are special conditions that they should be able to consider. So I don't view this as a minor change, and I guess I'm concerned that there's probably a lot of case law built up under the language that you're trying to remove. So I guess, do you have an overwhelming justification for doing that? Because I guess I would not be inclined to support that change.
Okay, I understand your position. I think if you had looked at the cases, very few of them, if any, focus on special conditions.
Yeah.
And most of them look at the hardship prong specifically.
Yeah.
And we're not trying to eradicate that.
Yeah, understood. Okay. And then just to clarify, under section 3, I mean, I don't think in most cases, I understand there's sort of a unique circumstance here, but conversion to a condominium would not, under most ordinances, trigger a subdivision in your experience, right? It's just this particular circumstance you're trying to address?
No, 356B has a specific section on that. That it prohibits municipalities from refusing to allow a property owner to convert a fee simple structure to the condominium form of ownership, but that does not extend to the state or administrative bodies.
Okay, got it. Okay, thank you.
Senator Ward.
Thank you for taking my question. So you're gonna convert the building and have condominiums?
Microphone.
There we go, okay. We're talking about a conversion of a building to condominiums. How do we get from that part and dealing with the ZBA to the amendment that has to do with ADUs.
They're not related. The ADU piece and the condominium conversion piece are totally unrelated. You could pass one and not pass another, and it would have no impact on the subdivision and the condo conversion piece.
So that's totally separate from this
All
bill.
three of these are totally separate, and in retrospect, it probably would have been better to do 3 separate bills, but that didn't happen.
Okay, thank you.
I did have a question. If this conversion causes a property to be more non-conforming, I don't see why I would want to take the planning people in the town or city out of the process.
You wouldn't. The 356B and the zoning statutes allow communities to review condominium conversions. And we're not suggesting that this bill, and we don't intend to, or it's not the goal, to make anything more non-conforming. The goal would be to make it more conforming. And we have, there's no language or no intent to deprive the municipalities from the review that they currently undertake.
My comments really came about your comments to the septic system. That these type of properties, normally it is not one system per, property, per
Building.
But a combined system where there would need to be, specific agreements, about that, some kind of an association established and this whole thing. And still, because you may be adding kitchens, which is another criteria that the people over in DES talk about when they talk about systems and the capacity for that system. Is that all covered?
Well, DES's rules now on septic, they're generated by soil quality and lot area, and it takes into considerations of bedrooms, kitchens, sinks, but most of the density, or all of the density, is based on bedrooms. That's why the language there at the trailer says no increase in bedrooms or footprints.
The point would be, if it will never qualify under the new agreements or the new laws, why would I want to allow it to go forward without it either reducing the number of buildings, bedrooms, kitchens, so that at some point it would come into compliance?
Well, at some point, it is when, I think in this particular case, as with many, they'll stay the way they are, properly maintained and cleaned with an old septic system. And I'm not sure if it was Oliver Wendell Holmes, but someone much smarter than I said, when the law cries out for justice, it's time to change the law. We think that this minor modification with the appropriate tweaks, and as I say, I have great respect for DES, and they've been very helpful, and they have the environment forefront in their mind to do things that don't cause any impairment to the water. In fact, the goal here would be to provide a benefit, because in honesty, if these can't be converted to condos, they'll stay as they are. I put some pictures in. I didn't go over them because of the time limitation, but you can see the density of the improvements. If you cut that by half, that's not going to happen in our lifetime. And there's a lot of septic between now and then, hopefully.
Additional questions from the senators? Seeing none, thank you very much.
Thank you all for your time.
To get a little balance here, I'm going to go to NHMA, ask you to come up, and DES, unless you have an objection, I'm going to hold you out till last. Okay?
Do my housekeeping.
Thanks. Nate Grace for the New Hampshire Municipal Association. So as the last speaker clarified that these 3 sections are not related, I'll speak about them separately here. So the first section about the ADUs, we don't really have any issues with that. Our reading is that pre-existing non-conforming use, as long as it's not going to expand the nonconformity, it's basically the same thing as the statute already requires, so it doesn't seem like that would be a big change. We do object to the second section here about variances. Variances are only granted because of the special conditions of property. There has to be something unique about the property itself that would not allow it to be used in a way that the zoning ordinance allows it to be used in, but it would be unfair to allow the owner not to use it in that way. So that's a really critical piece of why someone would go and get a variance and be qualified for that. Essentially, if this change were to go through, it would significantly relax the granting of variances under 674-33 Roman 1B2. It wouldn't change the other standard under 1B1, but essentially what it would do is abrogate the ruling under Governor's Island Club versus Guilford at 124 NH 126 from 1983. That could have a pretty substantial change in how zoning boards operate and exactly how they are granting variances. As the last speaker noted, this apparently is not a municipal problem. This is apparently a training problem with Superior Court judges. So we don't think that it would be fair to change the standard for municipalities when clearly they're following the law, or at least. The third section, we do have some concerns about and how that would function in reality. We've certainly heard extensively about this one particular septic issue. As far as, any sort of local issues, it would seem the case that they might be able to go through the variance process. Sounds like there's a lot of local support for this, for allowing this particular property to do what it wants, and it might be more effective to deal with this on its one-off basis rather than making a substantial change to the law that could have some sort of unintended consequence. And I'm happy to take questions.
Questions from senators? Seeing none, thank you very much.
Thank you.
Robert Roulette? Mr. Willett? He didn't indicate whether he was speaking or not, but, okay. I just wanted to give you the opportunity since it was your property that we were discussing partly. Okay. Len Galvin.
Thank you. I just want to speak in favor of the bill. I'm Len Galvin from Fortune. Okay, thank you. Len Galvin. I live in Concord, New Hampshire. We've lived in New Hampshire our whole life. I grew up in Alton and I'm married to one of the Willettes. Jill's my wife. I'm in favor of Senate Bill 244 and hope to gain your support. There are many properties around New Hampshire that are beautiful properties and some have been existing structures with utilities and facilities that have aged over time. These properties continue to be lived in or operated as businesses using existing infrastructure that are substandard to today's technology. Senate Bill 244 will help bring some of our aging buildings and infrastructure into today's standards by allowing developers to repurpose older properties into newer homes and condominiums. There are many homes and businesses that will continue to keep the same inferior systems going until they fail, but with the opportunity of repurposing, developers will be able to justify the infusion of money to help upgrade or create new infrastructure. This in turn will help our environment. Senate Bill 244 will also help our state's ongoing housing challenges and help upgrade our facilities to more conform to the codes of today.
Questions from committee? Thank you very much, and I guess it's Jill's turn.
Thank you. My name is Jill Galvin. I'm a Willette. I'm one of the owners of Sandy Point Beach Resort in Alton Bay, New Hampshire. My family has owned, operated, and lived at Sandy Point for 3 generations. My grandfather bought the property in 1929, and we've done our best to maintain and upgrade the property to the best of our ability and means throughout the years. I'm in full favor of Senate Bill 244. The bill will allow the property to be upgraded and get closer to conformity. Allowing the conversion would have a positive impact on the town tax base, the environment, and aesthetically improve on some of the aging buildings. I would love to see the property have the opportunity to be somewhat similar to its current appearance, but upgraded with high-quality facilities and newer structures. We are currently not able to provide the amount of work that needs to be done to improve the property, as the business does not support this level of monetary requirements. The septic system is very dated, but it is held up through the years with some fixes, and it has done a remarkable job. However, it would be nice to have a complete overhaul. The opportunity to convert the business into condominiums would align perfectly with our views on how we would like to see the property continue to grow and improve. It would give it new life and love that we are unable to provide. We only found out about this committee meeting on Wednesday, and over the past few days, we have generated a tremendous amount of support from New Hampshire residents to pass this bill. My husband and I have had 75 signatures, and with all the other signatures, we have well over 200 signatures in just a few days. And I speak for myself and my brothers that are here, that we would greatly appreciate your support to pass Senate Bill 244.
Questions from the senators? Thank you very much.
Thank you.
Chris Norwood.
Good afternoon, Mr. Chair, members of the committee. My name is Chris Norwood. I'm the 2022 Chair of the New Hampshire Association of Realtors Public Policy Committee, and I come on behalf of the New Hampshire Association of Realtors to speak in favor of Senate Bill 244. As you have already heard details of the bill, I'll just speak briefly on each of the 3 points. Having just read the amendment, I agree with the prior speaker's comment that I believe it sounds like it's a reasonable solution, perhaps with some tweaking relative to the aforementioned example of a gazebo that would be sitting. Can you turn your? Oh, it's not on. Testing, testing. Is that better? I'm very sorry.
Anything you wanted the public to hear, you should repeat.
My name is Chris Norwood, for the record, 2000 Association of Realtors Public Policy Committee. Yes, I agree with the first section relative to the amendment and perhaps the example of the gazebo within a setback. But in general, we're for private property rights, and if there's a building, again, forgetting about the lake example, but if there's a building sitting inside someone's setback and it is otherwise non-conforming, but there could be a future use for an ADU, I think that this is a reasonable proposal. Relative to the Section 2 on the special conditions, we agree that striking that clause will allow for better clarity. And then finally, with the existing improvements, I think it's a better codification of the subdivision is not triggered by a condominium conversion, is kind of the short of it as I read it from a lay person's perspective. So with that, I will entertain any questions.
Questions from the senators? Seeing none, thank you.
Thank you.
You can just leave it on. If you leave it on, then they don't have to turn it off or on. DES. Philip. Just give it to Trish. All right, she's already got it. Thank you.
All right. All right. Thank you, Senator Gray, and distinguished members of the committee for this opportunity to testify. My name is Philip Trobridge. I'm the manager of the Land Resource Management Programs at New Hampshire DES. Both the Shoreland Program and the Subsurface Systems Bureau are in my group. I believe the speakers before us have already covered the first 3 sections of this bill very adequately, and I'll move on to the 4th section regarding the subdivision definition. And regarding this change to the subdivision definition, the bill proposes to change the definition by excluding condominium conversions if there are no changes to the structures or the number of bedrooms. And my staff are very customer service oriented. We try to get out of the way whenever we can and to help people and to reduce the amount of burden on them. Unfortunately, this is not one of those circumstances. We feel that it's appropriate to reduce this definition. So the reason why the definition of subdivision is important for us is that any subdivision of land that is not served by municipal water and sewer needs to get a septic system approval from DES. And for this approval, DES looks at the lot, whether or not the lot on the structure, on which the structures will be located can manage and treat all of the wastewater for the intended use. The review process by DES serves several functions. And this one that has not yet come up is, first, it protects the buyers of the subdivided property. All parties to the transaction have the assurance that their investment can have a compliant septic system. Second, it protects public health. The vast majority of homes in our state use wells for drinking water. If you have a septic system that does not meet state standards now, it puts the property owner as well as their neighbors at risk of illness. And third, it protects the environment. The clean water in our lakes and rivers is a major draw for New Hampshire's recreational economy. Failed septic systems release nutrients to surface waters, resulting in problems like algae blooms. So getting back to Senate Bill 244, and let me give you an example why this is important to look at condominium conversions. We often see proposals for condominium conversions for old waterfront camps that have multiple structures like cabins. And I'm speaking in this case very generally, not about the specific property in Alton, because there are hundreds of these properties around our state. In these cases, the lots are typically too small to handle all the wastewater for the structures that are on them. The septic systems themselves often predate our DES jurisdiction and do not meet state standards. And when a septic system on one of these properties fails, which it will because septic systems have a finite lifespan, they last about 30 or 40 years, it's going to need to be replaced with one that meets the current state standards. And this creates two immediate problems. One, it may be impossible to put a septic system on that property that meets the lot loading requirements due to the number of structures that are there. And then two, the newer systems often require just more space than the older systems. And so it may require moving a structure or two in order to accommodate it on the lot. These problems are surmountable when you have a single owner. A single owner is able to make decisions about the property, about what structures need to be removed or moved in order to meet the current requirements. And they can make those adjustments. However, once the property has been subdivided through a condominium conversion, the individual property rights of the multiple owners could make a solution impossible. Whose cabin would need to be moved or removed? How would they be compensated? In the meantime, all of the property owners, so based on our experience dealing with multiple cases of this type of situation, we think it's the responsible thing to do for the owners and for all people involved with the transaction to obtain the septic system approval prior to the condominium conversion to avoid this type of situation. The other argument we hear is that the property has had the same septic system, for a long time, forever. And therefore the expectation is that it won't fail. And we know that that's not the case, but in some cases, septic systems don't fail. And the reason for that is that they are in failure. What this means is that a system that is in the groundwater is, being flushed regularly by groundwater is passing through the wastewater, but it's not treating it at all. And it's resulting in pollution of the groundwater and the surface waters. Again, DES feels that identifying these systems during a condominium conversion is the best way to protect public health and the environment. A couple of arguments that have come up today are that it's better to improve the current, the situation from what it is currently. And I certainly agree to that sentiment, and I appreciate that from those who testified earlier. So the idea would be if these systems are not working very well now, and maybe they're at the 25% level, and wouldn't it be better to get it to the 75% level? The problem is that we are not allowed to waive. There's setbacks to groundwater, the vertical distance to groundwater, setbacks to surface water, setbacks to easements, and setback to very poorly drained soils, which are basically wetlands. If you're getting to 75%, you're probably having to waive one of those requirements, which we're not allowed to do for anyone else by statute. And so it sets up a waiver opportunity that's not fair to others. So therefore, in closing, DES recommends Senate Bill 244 be approved only if the proposed change to the definition of subdivision has been removed. And thank you. I'm glad to take your questions.
Questions from the committee? Seeing none, thank you very much. The second list listed Lori and Rick. Rick said no for testifying. Lori didn't specify. I'm assuming it's a no. Okay. Is there anyone else out there? Seeing none, we'll close the public hearing. And we will start the public hearing on Senate Bill 2, developers and municipalities on municipal trash removal fees paid by condominium owners and renters. And we'll recognize the prime sponsor.
Thank you, Mr. Chair and committee. For the record, my name is State Senator Tom Sherman, District 24, and I'm introducing SB 245. I filed this bill in response to a constituent complaint. The goal is to allow a better understanding of the circumstances under which a developer and municipality reach an agreement that the future residents of the condominiums will have to pay for municipal trash hauling, even though this benefit does not apply to them. While agreeing with my constituent that this arrangement by its nature is unfair to residents, I wanted to be certain that all aspects of this arrangement could be explored and that any remedy would take into account the input of all stakeholders. I've subsequently come to realize that there are two instances in which residents of apartments and condos might be without trash hauling, even though they're paying for the service. And one is that it's a pre-development decision between the town and the developer, and the second one is that the town may subsequently decide we're not going to change your property tax level or your municipal trash fees, but we will no longer provide the service to you. So the question that the committee would tackle is, if you are paying for the service, or should you be paying for a service that you're not actually receiving? And that's the goal of this bill. Happy to take any questions.
Questions from committee members? Seeing none, thank you very much.
Thank you.
All right, Scott Wolf.
Good afternoon, Mr. Chairperson and members of the committee. My name is Scott Wolf. I'm here in dual capacity. I own a property management company that handles approximately 14,000 condominium units. I'm also a member of the CAI, Community Association Institute Legislative Action Committee for New Hampshire. Our position is we would like to support the study that is being proposed, and basically support the association owners getting the same services as part of their real estate taxes that all other constituents get as well. That's it.
Questions? Seeing none, thank you very much.
Thank you very much, everybody.
Paul?
Good afternoon, everybody. Didn't get the last name, did you? A nice Polish name.
Well, you know, sometimes you don't even try.
It happens. I've been cursed with this for 60 years. It's okay. Well, good afternoon. I'm Paul Okanakin. I'm also, like Scott, representative for the New Hampshire Condominium Association Institute Legislative Action Committee. And the management company that I work for, we manage about 350 associations, about 26,000 units. And one of the things that we face every last quarter of every fiscal year is when we sit with these boards, these condo boards, and do budgets, is what are we paying for that we're not getting? And usually I don't want to say argument, but the disagreement comes in and the pressure comes in from our condo boards, which are elected. It's a great form of democracy. It's a wonderful process, as the trash and essentially street lighting, plowing, street repairs. Folks in condos are paying the fair tax rate, but they're not getting the DPW services that the towns enjoy that a normal homeowner would get. And I think that's where probably the rub with this is that there are services that the condo owners are paying for basically double with their city taxes and also through their condo fees, and only getting one set of services which are private. So, you know, the support of this is, as we do for our associations and our communities that we run budgets for, and I understand and I can certainly appreciate the municipalities not looking at this favorably, but if you were sitting in a restaurant and the person beside you got more food than they did basically because of where you lived and you paid the same, there would be a problem with that. So there are some things that hopefully we can all agree on and maybe move forward with.
Questions? Senator?
Scott got off easy and you're gonna get, okay, I get it.
Well, I live in a condo, so I just want to be upfront.
Welcome to the club. So do I.
I just want to make sure that I've got this clear. So the condos, as we get trash pickup every week. So, and I know that's in our condo fees. But when the town gives or has trash pickup, and the citizens in that town are actually, through their taxes, they're paying for that pickup. So what this bill is trying to address is the fact that condos and HOAs actually pay twice for the things like trash pickup.
That's exactly it.
Okay, thank you. Just clarification.
The double dipping and all those other little things that you can call it. But it's very frustrating because, you know, folks move into condo communities and many people think condominium is French for concierge, and it's not until the bills come around. And when you take the DPW aspect of condo communities, yes, they can mow their lawns, they can, you know, paint the buildings and do the roofs, but the DPW aspect of the plowing and the street lighting and things like that costs these associations quite a bit of money collectively throughout the state. And this is a way, in towns, you know, the towns are collecting that tax revenue and absolutely not providing that service. You know, I don't know where anywhere in the country you can collect a fee and not pay a service and have it be legal. I started when I was 10. And it's one of those that this has been an ongoing thing for years and years and years with condo communities and homeowner associations of this, when especially it gets heated up in the budget season. So your attention to this would be greatly appreciated.
Additional questions? Thank you very much. Peter?
Hello, my name is Peter Sorrentino. I reside in Hampton, and I'm representing myself, and of course, many other people this would apply to, but a few years ago, I bought a condo in Hampton, and I sold my house of 30 years in Manchester. My goal was to downsize from my large house to a condo, obviously, save some money and minimize the amount of work I had to do. Well, I've learned a lot of things in that process. The first thing I learned is that after you've had a house for 30 years and for 30 years filled it up, it is quite an endeavor to move from that house into a condo that is less than half the square footage. So that was the first thing I learned, but not particularly relevant to this hearing. The next thing I learned is that it's not nearly as economical as you might think it would be. And one of the reasons for that is this trash policy that many of the municipalities have who offer municipal trash service. And that is that I discovered after being in the condo, the first time I've spoken
We would
Concord.
rather you speak from your heart, not from your iPad.
Yeah, I understand. I just never been up here before. I'm a little nervous, so
all
I'm
right.
trying to guide myself a little bit with it so I don't forget things. I thought I'd take the approach of just describing to you my experience. I moved into the condo. I love it. But what I've discovered is that the fees are high. It's quite expensive to do that. And the reason is there's a lot of things that condo owners are subjected to that homeowners or house owners are not. One of those things is this policy, this behavior of the municipalities around trash pickup. During the purchase of my condo, I saw that the municipality does offer trash pickup, but wouldn't to me. And I thought, well, that was fine, because I had lived, prior to my house in Manchester, I had lived in a house where we contracted for trash service because the municipality didn't offer it, and it worked quite well. Pay the private company, they come pick up your trash, that was fine. I thought that's what we'd be subjected to, in fact, we are. But what surprised me was that there's no abatement for our trash pickup. So they're not gonna provide it, but they also are gonna collect the money for it in the property taxes as they would normally. And I felt like, well, so I'm subsidizing everyone else's trash pickup, but I can't take advantage of it. And I thought that was just really quite unjust. I didn't understand it. I'm not a lawyer, so I might use some of the wrong words, so forgive me for that.
You're fine.
I found out that the developer, in order to have the plan for the condo built, had to sign away the trash pickup for all the owners in perpetuity. So anybody who owned on that property would not be eligible for the municipal trash pickup that they were paying for. Of course, the developer did that. None of the owners participated in that, but we did know that they wouldn't be picking it up. What we didn't know was that there'd be no abatement for it, or there'd be no compensation for this lack of service, even though we needed it. And a lot of people confuse the issue in that, as a community member, I know I pay taxes for things I may not need. That's fair. It's part of being a community. But in this case, I needed the service. I was just being denied it while most other people got it. And that's where I find the injustice. In any case, I sent email to the selectmen in town asking them about this. The veteran selectmen would say, yeah, well, this has been going on for years. It's what we do. I felt like I was just told, go pound sand, too bad for you. Everybody was very polite and nice about it, but some of them wouldn't answer the question, just avoided me, and others just explained it is what it is, we've been doing it for years. Newer selectmen had an interesting reaction. Most of them didn't know, and like me, for most of my life, I was a homeowner, I didn't realize this went on. They didn't either. And I explained the situation, I explained the contractor's situation, et cetera, the developer, and they said, well, this doesn't seem right, I'm gonna look into this. Doesn't make any sense, doesn't seem right. They'd look into it, and sure enough, after calling them back a couple of times or emailing them a couple of times, I'd hear back, usually, not always, and the answer was, they always have throughout my life. The trucks can service us exactly the way they would anybody else. And he explained, well, that won't happen. They won't pick up your trash anyway because of this agreement with the developer. He explained to me this is a similar situation to not having children and having to pay for schooling. And I corrected him and I said, no, it's not that at all. In this situation, I have trash. You know, it's not as though I don't have any trash. I don't expect people who don't have trash to not pay the fee. It's part of the community service provided. And I said, you know, we have the trash, we need it picked up, we're paying for it, but you're not providing it. He went on, and then he explained to me, and that's, I guess, how it got me here today. He explained to me that we're not allowed to do this with sewer. If we don't run a sewer, Hampton also offers sewer service, as does Manchester. If we run a sewer line and we charge in your taxes, as Hampton does for sewer service, and you're not able to hook up to it because we don't have, why wouldn't you do it for trash? He said, because the state law requires we do it for sewer service. We can't omit children. I said to him, well, you know, with the school analogy, well, will you ever have a subdivision where you just tell the developer, whoever buys in this subdivision, you have to sign away their rights for public education, public funded education? And he said, no, we can't do that either. But he said, this is legal, and so we do it. And that led me to contact my representatives, my state representatives, including Senator Sherman. And that's more or less what brought me here today, is just trying to rectify this injustice. I find it interesting that right now the law appears to be, I'm not a lawyer, so forgive me, but there seem to be separate sections for areas where municipalities maybe historically try to do some of this. I'm sorry, I don't know how to call it anything but kind of shenanigans. I mean, I'm a quarter Irish, and my grandmother used to use this term all the time where, you know, all right, well, we're going to collect money from everyone, okay, and we're going to give it back to just those that we like. In any case, I'm here hoping that the state will study it and determine how clearly it is an injustice and correct it.
Okay.
Thank you very much.
The questions from the senators? Thank you very much, Peter. Anybody else out there that, okay, we'll close the public hearing. And I guess the next one is Senate Bill 246, Qualified Private Communities. You can stay here. We've got the microphones right here, which is okay, and we'll recognize the prime sponsor.
Thank you, Mr. Chair, and thank you, committee, for hearing Senate Bill 246. For the record, my name is Regina Bursell, State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And speaking of private roads, 246 was basically brought on because of the Condo and the Homeowners Association. It was requested from constituents of both Senator Carson and myself regarding residential condominiums and the private road issue. We found out that, and obviously I live in a condo, we have the same issues, but we found out that a lot of these condos and these homeowners associations are actually considered private roads. As we saw with the trash pickup, you pay for taxes for trash pickup, but you're not getting the service. And it's a little bit the same way. You're paying your taxes for the condo, and it's not cheap anymore, but you're not getting the services of the private roads. And so what Senate Bill 246 tries to address is the fact that some of these roads are not built up to the same standards as the town roads. So they disintegrate a little bit faster. And what 246 tries to do is put a little bit of cushion between the condo owners or the homeowners when it comes to having to redo the roads. So what it's requiring the developers to do, to put money into kind of a reserve account that would allow them to have some kind of basis that when the road needs to be repaired or redone, then there is a reserve fund for them to at least start. Because I know what happens is the condos get assessed, and it's a huge chunk of money to repair these roads. We just had ours done maybe 3 years ago. Luckily, I mean, our road was 30 years old, and we were told by someone who's one of the realtors that we're lucky that they're still able to sell some of the condos, so we had to repair the roads. But you're talking a significant amount of money to repair the roads, especially if they're not built up to the standards of the municipality. That means they deteriorate much faster, and the condo owners are responsible for repairing those roads at a much faster rate. So this is what Senate Bill 246 tries to address. And with that, I'll try and take any questions. But I believe there are some people here to talk about that.
Questions?
I just had one, and if someone else is going to explain. So the way I read the bill, this would be to establish for any prospective developments, those that, such as your circumstance currently exist, would there be the ability to establish one of these funds to begin to save up going forward, or is it just for future?
And that's actually a really good question. My thought is it's for going forward in the future. Because obviously some of these like ours are already built 1991, so there's no way for the builder to put some reserve in there. So it would be any going forward.
Thank you.
Additional questions from the committee? Seeing none. And this time, Paul, will call you first, and then we'll call him second in case they,
This is my first time, I'm just nervous as hell, so anyway. No, I do this all the time. Thank you for calling me first. You were seeing me doze off back there, weren't you? So that's okay. Here we are again. Do you need me to repeat what I mentioned about 5-10 minutes ago? Paul Okenak?
You should, because anyone
Separate bill.
who clicks on the link to this is only going to hear the testimony that you make on this bill.
Understand. Paul Okenak, I'm from Nashua, and I represent a management company, Evergreen Management, that has about 250 associations, about 26,000 units. And I also am a representative of the Legislative Action Committee for Community Association Institute of New England and for New Hampshire. It's kind of funny, I doing this and where we go for condos and their budgets, and sit with many, many elected boards, and it's a wonderful form of a micro-democracy, and it's a great process. But we do face, as a matter of fact, we picked up an association recently, God bless them, they're not that old, and their roads are crumbling. And here's what is that the insurance company, that the master policy for that association came through and did a risk assessment. And that insurance company recommended and said that they have a certain amount of time to repair the roads, or they could be either not insured or the premiums go up because it becomes a hazard. That's an unfair burden to the associations for those private roads that were built, and a lot of times developers do them very quickly. It's the last phase of the development when they're ready to pull out and sell the last unit, and they throw a top coat on some sand, and these unsuspecting condominium owners buy in, and it looks nice and paved and pretty, and within a number of years everything starts to crumble. And also part of, I will say and be so bold, the problem with this is some of the municipalities on their engineers and some of their town leaders that are to inspect these roads don't really go out and make sure the base and the base coat and the top coat are the thicknesses and the rolling and the compaction that they should be either. So here's these unsuspecting unit owners that buy into a beautiful now $500,000, $600,000, $700,000 condominium unit and find that the things that maybe weren't built to spec or won't last that long. And it's unfortunate because it's kind of funny, during some of these budget things I mentioned earlier, I kind of segue into this, the DPW aspect that the associations get is that we kind of talk to the boards and see DPW stands for don't pay for work. And that's what these associations do, is they don't pay for work when the cities and towns get the DPW services. So having some type of mechanism for accountability, whether it's a reserve, and if I may add, with your bill, there has to be a stipulation involved that if this were to come to fruition and the developer is to put money away for the association for roads, it has to be separated and segregated just for roads. Because many times associations get a little pool of money from developers, and all of a sudden they're taking care of other issues that come up in the association, and that road money will quickly evaporate, and its intended use will not be what it's used for down the road. We have many associations that have developer issues with drainage and road issues and storms drains and things like that walk away, and the associations are left there with these messes to clean up. And I think this is an absolutely wonderful first step on making sure these associations that the developers build, the communities and towns approve, and the association members that buy in, there's some accountability and some history there that they can count on to have things, make sure it's done right.
Questions? Oh, Senator Birdsall, I saw you first.
Paul, thank you for
Yes.
testifying. I know in my conversations with the New Hampshire Private Roads organization, one of the issues that they had, and I just want you to basically confirm, is there have been cases where the condo owners and the home associations have asked because of the maintenance and because of the plowing during the winter, they've asked the municipalities to take over the roads. And oftentimes the municipality refuses because they're not built to the standards of that municipality. Is that correct?
Right.
Okay, thank you.
So it's kind of a damning thing when you buy in and it's a lovely road but doesn't meet requirements, but yet you have someone that's developing a neighborhood and a community with a wonderful tax base for the community, but they aren't getting the same quality as that would be out there. And that's up to anybody's standards, really up to the individual towns and their coding and permitting. So it's a really open-ended process that condo associations and their owners are left to face holding the bag.
Senator Park, you follow?
So would it be advantageous to require the builders to build those private roads to the standards of their local municipality?
That would be a wonderful first step. It might be, dare I say, an alternative to funding a pool of money that is there. Because what we find is that when we enter into an association as the management company, and it's coming off the developer, there are usually bonds that the towns hold for completion of work for the developer, and as soon as the last bit of pavement goes down or the last CO, certificate of occupancy is granted, the developer's gone and the bond is written back to the developer, and the tail light theory, he's gone, you see the tail lights of his car going away. no more accountability. And I've sat with more attorneys and associations that have developer issues such as these things, and there's no relief for anybody because they're all gone. But that's also a wonderful first step to maybe bring those standards up, and that would right out of the gate in the building, and that might alleviate a lot of the problems.
Thank you.
Senator Spoka.
Thank you, Chair. But Senator Birdsall went directly in the direction I was going, which, no, I just was wondering whether any municipalities had been approached, to ask the question if these roads were built to the same standard, would they accept them and would they maintain them? And I guess a second question down the same road is, have condo associations ever considered, or have you seen any where developers proactively entered into, say, a pilot with the town, to sort of perhaps have a reduced tax rate in exchange for taking on the maintenance of the roads?
No, developers, and again, I'm going with a broad brush approach here. Developers want to get the plan approved, and to do that, the towns have concessions that the towns don't need to worry about, or developers have concessions. And with that being said, that gets the plans approved pretty quickly. And that way, things can be built like roads and whatnot at a little subgrade, as long as the towns, they get another 60, 80, 100, $120, 120 unit homes at a tax rate of $10,000 a year each. And the level of services is don't pay for work. So did that answer it a little bit?
Well, she has a follow-up question, so
Okay.
if you didn't, she'll ask you.
That's why the mic's still on over there. I see that.
Yeah, and again, I don't know if these questions are properly directed to you, but, I mean, in many condo associations, there are reserves established. There's nothing prohibiting an existing condo association from using their existing reserves, or probably many do, to maintain these roads, correct?
That's a very loaded question.
Okay.
May I have a moment
Sure.
to explain it?
Yeah.
It's interesting because in New Hampshire, we go by the individual condominium documents for reserve savings, if you will. And those are in the documents, the boards are to put adequate reserves. That's how it's written. FHA, though, when you apply for a loan, the banks look for reserve contributions of at least 10% of the operating budget. So if they bring in $200,000 in condo fees, the board should be putting 10%, $20,000 away. What happens is now in this industry that is maturing, that, in the last 30 years in New Hampshire, is so many associations do not have adequate reserves. Now, the Florida condo collapse that happened almost a year ago, there's a situation that absolutely puts this to the forefront. Who was at fault? Was it the builder and designer? Was it the engineer that pointed out the problem? Was it the board that did not raise the fees to adequately fix and repair? Or was it the condo owners that did not want to face an assessment to repair those things? That's why last I've heard there's 40-some lawsuits with that, and it's very unfortunate. But that's a macro of the micro of what we're dealing with when boards sit in, because I know we're all elected officials in one way or another, but when condo boards get on, it's the no new taxes, no new condo fees. I'm going to get on to keep them low because there's so much fat in the budget. I've never seen a condo association budget that has any fat in it. So with that being said, the fees stay artificially low. Boards do not anticipate, they only think of the next quarter, not the next quarter century. So when you're starting to establish these budgets or reserves, keep getting the savings get dwindled because, oh, the electricity went up, oh, the road paving went up, oh, all those things that, landscaper went up, all those things go up, the reserves are usually the last consideration. So what's happening now is after the Florida condo collapse, there are reserve engineering firms out there that will come to an association that will say, we will look at your infrastructure and help you plan for those infrastructural improvements or betterments or replacements, roads, septic systems, sewers, things like that. They come up with an amount. And usually the amount to save for those is very high. Then the boards go, uh-oh, we can't raise the condo fee $50 and $100 and $150 a month because our constituents won't approve that. So the degradation of those infrastructural things increases while the cost of replacing increases. So it's a trap. So where I'm going with this is the more that we can do collectively to help set communities, condo homeowner communities, off on the right path out of the gate, from being built to, I talk to many boards that are just coming off the developer and I consult with them, to set the condo fees appropriately right out of the gate to help prepare and plan for the future. So this is just a piece of a very important puzzle to help these associations and these communities, of which we manage 26,000 homes and condos, will help establish that. This is a very good thing.
All set?
I have comments, but no further questions.
Okay. Thank you very much.
Thank you.
And we'll call your cohort, Scott.
He's going to come up and say whatever Paul said, so be prepared.
He could,
You took all my questions, everything away. Hello again, Scott Wolf, Community Association Institute, New Hampshire, Legislative Action Committee, and also the owner of Briggs Property Management. I agree with Paul 100% that this is a phenomenal step for condominiums. Setting them up for success at the very beginning is probably the most important thing, and that does not happen. The developer sets the condominium fees. The developer is the one that allegedly sets the property up for success, but their goal of success and ours are two totally contradicting things. They want to sell units. We want to be able to operate these units into the future. What we find in taking over an association from a developer is typically the fees are very low. Within a year, you have to propose higher fees. Reserves are not adequate, and I agree with Paul, the requirement that it be adequate is just too vague. Even the requirements for a loan of 10% of your operating going into reserves, never adequate. It's just not going to happen. The buildings are looked at in the original construction by the building inspectors, the electrical inspectors, the plumbers. Roadways are not. And there is a deterioration of those roadways in a shorter period of time. Having some studies to show that they're being done to a quality of the municipality would be a wonderful thing to have. I'm of the same voice as Paul that this is a great first step. It's really getting the communities to see we need a reserve. When you start off on day one, just because the community is brand new, does not mean you do not need adequate money in the reserve account. One thing I'd love to reiterate that he said, have it go in escrow. Something needs to be done to put those funds for the roadways over here where they cannot be utilized for the swimming pool, any other amenity that they so choose, the siding, because it will be spent on something else. And if you have that in the bucket and it's set for that one amount, it is a much better thing. Because associations don't like raising fees. Again, it's volunteer constituents, they have the same thing. Taxes go up, we get upset. We raise condo fees, they get upset. So it is, I truly support from a management standpoint the bill 100%. I think it's a great first step, and that there are other things that could also be done into the future to help this. And unfortunately, Florida is hopefully going to change a lot of what's going on, because there is buzz going on that there will be a requirement for reserve studies. Reserve studies are typically about 3 inches thick. People look at them and they say, we can't budget for that. We're not going to put that money aside, and they don't look at other alternatives. It just ends up as a paperweight. Working towards having a better working financial model will really help. But we 100% support this bill.
Questions from the senators? Seeing none, thank you very much.
Paul took them all. Thank you very much.
John. And it looks like GOGL, maybe an IA? correct. All right.
Mr. Chairman, thank you very much. Vice Chair Bertzel, thank you. Good to see you again. The first thing I wanted to address, I have some handouts that I'd like to show the committee members. Should be 5 there.
If you have 6. that
I
would
only
go-
have 5.
Well, then save mine and give it to me later.
Sorry about that.
That's okay.
Mine-
We want to make sure it gets into the permanent record, and she's the one that does that.
Okay. My name is John Goglia. I have lived in Londonderry since 1984. The last 7 years, this is our 3rd house. The last 7 years, I live in a private road community in Londonderry. It happens to be an over 55 community. And I also, I'm here to speak on behalf of myself and on behalf of the New Hampshire Private Road Taxpayers Alliance, Alliance for short. I'm a director and the treasurer of that organization, and I'll tell you, when we get to the handouts, I'll talk a little bit about that organization. Why I'm here is to advocate for fairness and equity for people that live on all different kinds of private roads throughout New Hampshire. I'm glad to hear the 2 gentlemen before me that are in support of this bill. I think it's important. We feel that municipalities have broadened the term private roads over decades to benefit themselves and the builders. When a private road developer builds a private road community, they get many different waivers and variances, and in some cases, easements. The waivers and the variances pertain to slope, grade, width of the road, and these things suit the builder and the municipality, but they don't really help or benefit the eventual residents for whom they're building these communities. And why I'm here is to advocate for the people who have yet to live in a private road community. To answer Senator Soucy's question, this bill is about not existing communities, but communities in the future. We have no supporters for this bill other than those of us that have already lived through it. Just to give you a little bit more background on what the other 2 gentlemen said, back in January of 2020, town officials came to our community to talk to us about tax assessments and about a lot of other things that would affect a community like ours. They went out and talked to maybe 2 or 3 of the larger communities in Londonderry. They explained to us, the tax assessment process. They told us a couple of important things, that New Hampshire is one of 31 Dillon Rule states, and as a Dillon Rule state, unless the state grants municipalities the authority and the power to do something, they don't have that power. In effect, they can't do a tax abatement or anything for people that live on private road because they don't have that authority. That's a reason why we're here in front of you today, and that's why this bill was introduced. About a couple of weeks after that, myself and one of the board members from my community, we went and talked to our town officials, specifically the assessor's office, DPW, to ask them why we're a private road. They told us that the builder was granted 7 waivers and a variance having to do with driveway sight lines, and the variance had to do with modified setbacks of the residential units. And that the speed limit was reduced from 35 to 25 because the roads didn't meet those public standards. Well, our questions to them were, well, you standards. We talked about, getting them to do something for us, to provide snow plowing or whatever. They flat out refused, a lot of different reasons. Not in the budget. If they did it for us, they'd have to do it for others. We've got a lot of excuses. Didn't think this was going to go anywhere, but maybe about a month later, I found out about the Alliance. I've been with them for 2 years. At the beginning, I just started out helping out, and then I jumped in with both feet. I want to tell you a little bit about our community and the handouts that I gave you. First of all, the first handout talks about the, it's a photocopy, and not a very good photocopy, of a board that I have that marks all the communities, the cities and towns throughout New Hampshire that have signed up on our website that support what we're doing. There are a little over 80 now, probably 82. I don't know if there's 82 on that list, but it's front and back of the second page in that handout has a list of all the cities and towns that are represented by our organization. The third handout is a picture of the entrance to the community that I live in, and I don't know, again, it's not a real good picture, but if you look at the roads, we recently had them crack-filled. Our communities, at the time we had it crack-filled, it was less than 7 years old. Those roads are in bad shape. 2 out of our 5 roads are in very bad shape. We've been told that it's going to cost somewhere between $80,000 to $100,000 to fix. We've been slowly putting our reserve funds away in anticipation of that, but our fees are going up dramatically, increasing periodically because we're not going to have enough money to do that. We never expected that we'd have to replace roads in first 7 years or 10 years or whatever it is. Also on that entrance photograph are 2 arrows that show easements off of our private roads, one on the left and one on the right. Those easements go to commercial properties that are adjacent to our property. Our entrance is off of a main highway. The DOT maintains that highway, and we understand that they probably won't grant access and egress from the highway. Therefore, they have to use our roads, and hence we have the easement. I don't know how you can have a private road with 2 easements like that, one on the left, one on the right, that they're eventually going to be commercial properties. One of the properties, there's nothing been filed yet, but the rumor is they're thinking about a very large restaurant and an office complex, which is going to be a lot of traffic on our roads that need to be repaired, and we have to pay for those roads. The other thing, we have a third easement. We have a cell tower, approximately 200 feet tall, that's in the middle of our complex. Matter of fact, when I look out, my front door, I see that tower every single day. And that has an easement for them to service it. They service it a lot. It's kind of ominous sitting there in the middle of the complex. I understand if it ever did fall, it would implode rather than fall on one of the condo units, so that's a good thing. We have 5 roads, 2 of which are in need of repair, and I checked the mileage. It's about a little less than 1.3 miles, which isn't very much road to take care of. But and when you talk about a public road where the homes are bigger, the lots are maybe an acre and a third or whatever, maybe you have a handful of homes on a road that long. The handout has a picture of the cell tower and a picture of one of our roads going up the hill further. The reason why I tell you this is because we have heard this same story over and over again from other communities that their communities are cut through like ours. We have a front and back entrance from the highway. People cut through. They don't want to hit the traffic light. They cut through. There are a lot of other communities around the state that have the same issues. We have all of the delivery vehicles, the moving vans, and all the service vehicles that you can imagine that go along with a community like ours. We've also gotten feedback from other communities that their tax assessment is adjusted because they live on a private road, and as far as we can tell, that is not the case at all. We've talked to numerous people around the state, assessors and whatnot, the assessing board, and they couldn't come up with one community that does make an adjustment for people that are on private roads. I don't want to reiterate what was said before, but on a private road, you're responsible for everything: the infrastructure, the sewer, the water, the lighting, all of that, we're paying taxes. We pay as much, if not more, than other people in the communities that we live in, and we don't have the services. I wanted to just give you one example of what it is we're talking about dollars and cents wise from my community. During calendar year 2021, my community spent almost $80,000 for snow removal, street lights, and fire hydrants, which comes out to approximately $815 for each of the 98 units. We did some crack filling, as I said, on 2 of the roads at a cost of $4,365, or almost $45 per unit. Those roads are a mess. They need to be repaired much earlier than we expected. The estimates are around $80,000 to $100,000. We also had to do, after about 4 or 5 years of an existence, we did an engineering study, and we had to pay for that to have them come in to determine about our infrastructure, what needs to be done, what do we look at. We don't have that expertise. The municipalities do have that expertise, but they're not providing it to us. Talking a little bit about the HOA fees, previously, our HOA fees, like everybody else, start off very low because the developers want the initial buyers to buy the units. As you get year 3, 4, 5, you realize there's not enough HOA fees per month coming in to cover what you're going to need down the road, so your fees go up. We started at $225, we're at $252, and we've already been told it's going up next year too. And we expect things to go up, but not as quickly as I think they're going to go up.
Why don't we ask the senators if they have any questions, John? Because a lot of this information, it's detail on things that we've already heard.
Okay.
So, the senator, any questions?
Can I put out one thing to bring up
Yes,
something
John.
that Senator Birdsell mentioned? The fact that, why the roads, maybe the roads should be made to town standards. We had that in our bill initially. We took it out because we know we're getting resistance from the NHMA, from the developers and builders. We tried to make it more palatable for everybody. We think that there's the way the bill is structured, it's a win-win for the municipalities, for the developers, and for the eventual owners.
Okay.
And I can explain that further if you need me to.
Well, right now, NHMA is the next one on my list.
Okay.
So I will, if you're finished, I will call them up and we'll listen to them.
I am done. Thank you very much.
Thank you, John.
Thank you, Senator Gray. Nate Grace for the New Hampshire Municipal Association. We are not taking a position on this bill. We recognize this is a serious problem, as we've heard over the last hour or so of testimony. And even though we generally oppose statewide zoning mandates, this is such a minor requirement regarding city and town approval of plans that, given the scope of the problem, we think that's a reasonable compromise. There are only 2 things that I'd like to mention that haven't been mentioned today. One is we just want to make sure that the best term to use is capital reserve fund. It certainly describes what's happening here, but we want to make sure there's no confusion with RSA Chapter 35, which talks about a specific type of fund, which happens to be named a capital reserve fund, and that's held by the town. Clearly, these funds are not going to be held by the town. They're going to be held by private individuals. I think that's fairly clear from the language, but it might merit an extra line in there to clarify that. The only other thing that I wanted to mention was that we were a bit concerned about the town being caught up in the costing analysis for the road replacement, which essentially that's lines 28 and 29 for the bill. It may be a better option to tie the roadway quality to something like the state's geometric design standards, simply because that's a statewide standard. And if that was applied to private roads, that might make more sense. Certainly, we've heard a lot of the concerns today about, whether things are paved once or twice or potentially not at all. And different towns are going to do different things. If we had a statewide standard for the private road, that might just be easier to apply because then everyone would know what we're talking about. That's all I really had to add, and I'm happy to take questions.
Questions from senators? Senator Birdsall.
Thank you, and thank you for testifying. So when you say use, let's say, a state geometric design standard, so that would mean if someone were doing a building in, let's say, Hudson, and they know what the standards would be on those roads as this would be the same standards as being done in Newmarket.
Correct.
Okay, thank you.
Yeah, and those are statewide standards that are adopted by DOT. So I'm not exactly sure how they work because I'm not an engineer, but that might be a better approach.
Yes, ma'am.
Do the municipalities use those same standards?
Many of them do adopt those as their own standards, but some do not. It depends. It's really a local option for what they want their own standards to be. And they may have different standards for private roads than for roads that are, municipal roads, class 5 roads. So if the concern is that many of these roads are breaking down after 7 years or so, with just the residential traffic, it may be a better option to choose to, kind of fix the minimum standard to some statewide standard.
Yes, ma'am.
Sorry. But I wonder if it would get back to the same situation where if the developer built the road to the state geometric design standards, then the town, if it's not the same as the town, then the municipality can now still say, well, you're not, the designs aren't built up to our standards.
So if we're talking about 20 years down the line where we're asking the municipality to take over the road, that's certainly a concern. As these developments have been proposed, it's certainly possible for a developer to dedicate the road to the municipality as part of that process and say, I'm coming in to build a development. I want the municipality to take over the road and go through that as part of the approval process in front of the planning board. And for whatever reason, they didn't do that. In most of these communities, I don't know why, but that's the case. And so they decided to continue to hold the rights to the roadway themselves. And then they either give that out to, the private condo association or the private homeowners group or whatever the case may be, or they might hold it themselves. And then 20 years down the line, as we've heard, there aren't the savings. And so it's the case that many of these groups turn around and say, okay, we'd like the municipality to take over the road. And at that point, they're asking the municipality essentially either the select board to lay out the road or through a town meeting vote to accept the road as a town road. And there's going to be a cost associated because by the time they want the road to be taken over by the municipality, it needs to be repaved. So you're talking about, asking the municipality to take on that cost burden, which is what we're trying to avoid.
Okay, thank you.
Additional questions? Seeing none, thank you. Anyone else that has not spoken? We'll close the public hearing. And I'll pass the gavel.
Seeing it's past 2 o'clock, we will start the hearing on Senate Bill 425 FN. The prime sponsor.
Thank you, Madam Chair. My name is James Gray. I'm a senator from District 6. which covers the towns of Alton, Barnstead, Gilmanton, Farmington, New Durham, and Rochester. I'm here to introduce an old friend, the bill authorizing the Secretary of State to develop an election information portal. Certainly, I see the commissioner here and hope that he will testify. Certainly, we're trying to make it as easy as we can for people to either apply for or modify, notify the state of any modification that's needed to their registration, and I'd be happy.
Any questions from the committee? Liz Santarelli? Ms. Santarelli, can you please turn the mic on? Sorry.
No, that's my fault. Thank you. I will give my name again, Liz Tentarelli, President of the League of Women Voters of New Hampshire. And we support this bill, and I thank Senator Gray for bringing it here to the floor. The League's mission of empowering voters to participate in our election system will be fostered by the Selection Information Portal. And so that's all I want to say. I support this. Thank you. Let's get it on.
Any questions from the committee? Seeing none, thank you. Did you want to speak? Because I have, the only other name I have is Rusenchester Bedford, and he's not here, and he didn't want to speak, so.
Good afternoon, Mr. Chair, members of the committee. My name's Dennis Goulet. I'm the Commissioner for the Department of Information Technology. And I thought it would be interesting just to be able to explain the fiscal note a little bit, because it might be a little confusing. And certainly, you know, our digital government, modern digital government, is one of our strategic initiatives for the state. So anything that enhances citizen services on a digital platform is something that we like to see happen. And we like to see it happen in the appropriate way, which is part of how I came up with the fiscal note, and I'll explain that a little bit. When I was speaking with Dave Scanlon about this, maybe a couple of weeks before the fiscal note was finished, he was you know, we were talking about the functionality, which isn't really that complex, right? That it's not complex functionality. So the challenging part was, you know, making sure that if somebody comes to this portal, that we know they're the same person that they're representing themselves as. And then when they return, we know that they're that same person that we properly identified in the first place. So that's really and so we've been wanting to work on a project for a citizen access portal anyways. So what I did was burden the fiscal note with that initial implementation of what we call Identity and Access Management, or IAM, and that really has, you know, a couple pieces to it. One is that we, there is identity proofing, and there's various ways of doing that, but it's essentially proving you are who you say you are, and then, as I said before, when you come back, that you're that same person. So the cost over time is, for this overall, I would expect to grow, but the cost would be shared by other entities that were using this as well. So that we know the Secretary of State's office and other entities are interested in having like a business one-stop portal where businesses go and log in and have access to the various things that a business might do, whether it's, business with the Secretary of State's office or other entities within the state, making it easier to do business in New Hampshire. So that, we would want to design this around being able to do things like that. We know that multiple state agencies have requirements for strong identity proofing, like HHS for many of their benefits, or our folks over at Employment Security for unemployment. So over time, if we create a citizen access portal and we fund it through this bill, then we can use it for other things in the future, and the cost would get shared out based on that usage, as that's how DOIT allocates cost. So I'll just give you an example. We have an enterprise licensing system that's used by several different agencies. We bill out the cost of that by the usage of that system. So the agency that uses it the most, which happens to be OPLC, pays for most of the application. So our vision for this is similar. One of the things I will say, we were putting, at the time that this came out, we were putting numbers together for ARPA funding request to do just this, not the citizen voter information portal, but the citizen access portal, which is the lion's share of the cost here. So this potential, we believe that the demand for online services has skyrocketed due to COVID, so it falls into the negative aspects of COVID category for ARPA funding. So that there is potential for that, I think, in this case. But I didn't know how to represent that in a fiscal note, so I figured I would talk to it today. That's all I had for formal. Happy to answer any questions.
Any questions from the senators? Senator Susie.
So if I could, just to sum up, so what you're indicating is that the portal cost, as represented in the fiscal note, has the potential to be shared over several different agencies, so not completely attributable to the Secretary of State in this limited purpose.
Over time, right? So it's basically what we had considered for the ARPA funding request, which I haven't yet submitted, was getting 2 or 3 agencies that wanted to be first in, we call it, and then fund that, and then over time add other agency functions into it, so that the benefit to the citizens there is that that not having multiple identities to access state services.
Thank you.
You're welcome.
I do have a question. Anyone else have questions? I see none. I do have a question. Do you know, it's quite the expenditures. Do you know how that's going to be, can you explain a little bit how it's going to be funded?
Well, that was why I brought up the ARPA funding thing, because I'm not certain how this would be funded. Well, this could be, there's HAVA funds, that exists, and I know there's rules around that about how much you can use in any one fiscal year. There's statute about that, and there's options for funding sources. I would not be averse to seeking ARPA funds for at least the citizen access portal part of it, and I could separate that out if you wish. So we'd say the head count and the development cost of the portal itself would be, one chunk of money. The citizen access portal is another chunk of money that could potentially be an ARPA funding request.
Great.
Does that make sense? Yeah.
Thank you. Any other questions? Seeing none, thank you.
All right, thank you.
Is there anyone here that would like to speak on Senate Bill 425 FN but has not given the opportunity? All right, I close the hearing.
And we'll open the hearing on Senate Bill 427.
Perfect.
And ask the front counselor to introduce the bill.
Thank you, Mr. Chairman. For the record, Donna Susi, representing Senate District 18. And I am proud to speak to you today about Senate Bill 427, which would make some important updates to our New Hampshire elections. This bill would allow individuals, based on their own circumstances, to register and vote by absentee, and would give cities and towns the opportunity to partially pre-process absentee ballots prior to the election. This may sound familiar because essentially what this legislation is doing is reestablishing these procedures that have already been put to the test with incredibly successful results. In the 2020 election, when our state was faced with administering elections and a worsening public health crisis, it was clear that we needed to make some changes to the way we ran elections that year. With the input and bipartisan collaboration of state and local officials, changes were made to ensure that every eligible voter had the opportunity to exercise their right to vote in a safe and secure manner. The changes were achieved through House Bill 1266 of 2020, which allowed for these processes to move forward. Additionally, in anticipation of an increase in the number of absentee ballots city and town clerks would receive, the legislation had a provision to allow for partial pre-processing absentee ballots on Thursday, Friday, Saturday, or Monday prior to the Tuesday election. We know that more than 100 communities across the state participated in partial pre-processing, and based on the feedback from those officials, this option was critical to making their workload on election day more manageable, keeping voters' wait time shorter at the polls as they were entering and checking in, and ensuring accurate and timely election results. The effect of these changes were clear. Despite the fact that we were in the midst of a pandemic, voter turnout for 2020 was record-breaking, with 814,092 ballots cast. This was 85,000 more than the previous record for a high turnout, which had been set in 2016. Of all the ballots cast, 261,062 were absentee, which was nearly 3 times the previous high. As we're working to adapt to this ever-changing world, we continue to look at steps, just as we previously discussed with an election portal, different ways to modernize our elections. And in 2020, we had the opportunity to test some of these ways to modernize our election process, and we did so, as I said, with great success. So what the bill would do is codify in state law the ability for voters to vote by absentee without needing to provide a delineated excuse. It would allow these individuals, based on their unique circumstances prior to the election, to be able to cast their vote. And most importantly, as I said previously, to continue the process, if more people are going to avail themselves of absentees, to allow for pre-processing and to allow our election officials the opportunity once again to maintain, to deal with their workload at the polls, but equally as important to ensure that there is a continuous flow of voters coming in without having to wait in long lines. And one side benefit that happened as a result of pre-processing was the ability for voters to be contacted prior to the election to cure their ballot if there was an omission. That led many communities to reach out to voters and ensured that their votes were properly cast for the election. As I said, I think the outcome of the last election in 2020 speaks for itself. And here in New Hampshire, as we know, our elections are not run by the state, but by local officials. There's no question New Hampshire has a nationwide reputation for conducting fair, open, and accurate elections. And even in the face of challenges, New Hampshire has risen to the challenge. So I think this legislation is important to ensure that voters that have experienced this process can continue to do so, and our election officials can continue to have the tools they need to process those votes at election time. With that, I'd be happy to take any questions.
Questions from the committee? Seeing none, thank you very much, Senator. Liz Tettarelli.
My name is Liz Tentarelli. I'm president of the Nonpartisan League of Women Voters of New Hampshire, and we support this bill. My written testimony includes some of the same points that Senator Soucy made, but I'd like to bring to your attention the League's point of view as an organization dedicated to empowering voters. That is, to help our citizens understand that they can be part of the process. I think this bill will go a long way toward curing a few of the issues we have right now. One of them is, let's talk about absentee voting for one example. It's very hard for us to explain to people that there are rules about when or under which they can or cannot vote absentee. They're used to making adult decisions for themselves. Like, you know, it doesn't work for me to try to get to the polls on this day. I should be able to vote absentee. One specific thing is the requirement to check off disability if we're concerned about health in going to the polls. There are many people that I've talked to and that I've heard from town clerks and others who process these papers that say people don't want to check off disabled. We have too much respect for people who actually have disabilities to check off disabled as a reason to vote in the case of COVID. Now, you know, we had something else on the paperwork in 2020, and that helped a little bit, but now we don't. So just to say, if for you it makes sense to vote absentee, you may. Another problem we have sometimes is explaining when and where people can register. It's easy to say you can register at your town clerk's office ahead of time, except for those people who live in very small towns where the town clerk's office hours are limited and they don't fit the working hours of most people. It's very hard to say, well, the supervisors of the checklist will have a special session. And I tried to do that years ago when we had a specific date on which they had to do it, and they posted it in the newspaper. You know, it's that Saturday morning, and I gave the date, and it's from X hour to X hour in your town for a number of towns. That's when it was uniform. It's no longer uniform. Supervisors of the checklist have a range. And so although I can try to tell people that, it's not of much use. If I could add to that the fact that you could register absentee by contacting your town clerk's office and getting that paperwork, this would make a big difference to a number of people. And I do want to support the pre-processing of the absentee ballots. It worked well in 2020. I see no reason why we can't continue that process. It certainly will free up some of the confusion around when those ballots are counted, if we all know that that's a legitimate thing to do. So that's why I'm in support of this bill, in addition to all the reasons that Senator Soucy gave. And if there are questions, I'd be glad to answer them.
Questions from the senators?
Thank you for this opportunity.
Okay, thank you. There are 4 other people who have signed up. 2 have checked not speaking. 2 have not checked whether they are speaking or not. They're both opposed. Anyone who wants to testify? And with that, we'll close the public hearing. I will I will accept the motion to go into executive session. We have a second. All those in favor say aye. Aye. All those opposed? The bill that I think that we're all co-sponsors on, 425, is probably fair game. Do I have a motion? Move on to pass by Senator Birdsall and seconded by Senator Ward. Any comments? All those in favor say aye.
Aye.
Aye. Any opposed? We have a motion to consent. All those in favor say aye. 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 Opposed? And is there any other bill anybody else wants to try to do today? I'll take it.
Chairman, I don't want to try to exec this today, but I did just want to clarify
Yeah.
potentially the committee's timing for a vote on some of our redistricting bills. I know they're of great interest to
Yeah.
a lot of the public, and so I know that we have hearings on the House bills on Monday. And I just wanted to clarify as a committee that potentially we were waiting for that input before we would be voting on those bills, or?
Right. The two that I have scheduled for next Monday are, I think it's the county people and the delegates, which the Republicans use and the Democrats don't use that provision. So I thought that would be appropriate to get them in, get them, have a hearing on them so that we could exec those and get done with them. Right now, Senate Bill 50, I think I have on the schedule for the next Monday, and I have that scheduled for Reps Hall. And if I can, 50 is the state representatives, okay? And if there is any changes that we're going to bring up that haven't been noticed, there are some people out there that I've heard that would like us to change a certain congressional map, but I don't have one in my possession, so I can't publish anything. And there are people out there that have been burning up my phone saying that they would like the executive council not to remain as it is or be what it would be under the Democratic plan. And if those, either of those are ready to publish before the Thursday before that Monday, then I would intend to publish them. And that's this Thursday. Yeah, I understand, and I'm working at it. God only knows. It's been a wonderful week, and it's only Monday.
Okay, so just to clarify, I think while you were talking, you might have mentioned Monday instead of Wednesday. So this Wednesday, we have a hearing on the state party convention, delegates to state party conventions in the county commissioner districts
I
next
said
Monday.
corrected.
Okay, next Monday, we have the hearings on the HB 50 and HB 52. Obviously, we've had our hearings on SB 240 and SB 241, but we intend for there to be an opportunity to publish amendments to those in this
Right,
Thursday's
if there are
register.
amendments, we will try to do it at least by the Thursday before the meeting, which would be more than what we get on the regular bill.
Okay, I appreciate the clarity.
Okay.
That's all
and
I
so
had
that
on those.
Senator Susie can get out of here. I'm sure that she's got a motion.
Actually, I was going to make a motion, if we could, on a bill that we heard today where there seemed to be no controversy. Senate Bill 245 about establishing the committee
Oh.
to study agreements regarding the trash removal.
Sure.
It's establishing a committee.
Certainly, I'll
Unless-
open discussion on it. I see great similarity between 245 and 246. The same issues are out there when you're talking either roads or trash removal. There are a lot of the same issues out there. Who maintains the road in front of City Hall? Okay? And so how do I treat that? Do I have a private road in my community because I am restricting access and I have an access gate that may be manned? And that may increase the value that someone wants to pay for a property in that community. If I know that there's a condo fee that's $200 a month, then the amount of money I'm willing to pay for that piece of property in there may be less than an exact duplicate of it somewhere else in the city that does have trash removal, and therefore some of that difference is taken care of in assessing fees. And that is the words, since I do sit on the Assessing Standards Board, I did ask them about that kind of stuff, and that was their answer, is that a willing buyer and seller knows, you know, when they go into this, what the total cost of ownership is of a particular piece of property.
Not necessarily.
Well,
They could say all that they want, however, when someone is buying a condo or a home in a homeowners association, they know nothing about the roads.
so the bottom line is if
We don't wanna vote on
someone
these
wants
today.
to make a motion on 245, you are the committee.
What was your point? Do you want to combine the two?
I think that if you're going to do it, that combining the two and doing the study may be the way to do it. But we have heard from the people who it would advantage. We really haven't heard from the assessors. We haven't heard from a lot of the other people who would, at least told me when I went and asked them, that that's built into the price, and the price is what dictates the taxes, and therefore they are paying a reduced tax based on what a willing buyer and seller would pay. So would be my comments, right?
Move we come out of executive session.
We have a motion to come out of executive session. We have a second. All those in favor say aye.
Aye.
Now our business being completed, we're adjourned.
Right on time. Appreciate it very much.
All right. It's a tough one.
Well, I don't understand why, if the assessors wanted to put input, why weren't they here?
They don't want to put input. I had to go there and pry it out of them.
Well, then why should we be worried about what